In Court on TKO8 Television is brought to you by Campbell Bonding Company. Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
Boone County case CR 2016-232, State of Arkansas versus Austin Angel. There is also 2016-24, I can get it located. The same defendant. Yeah, I'm just moving back. Okay, it's on the revocation list, 2016-24. All right. The court is making the appointment of the Public Defender's Office to represent Mr. Angel in both cases, both the newly filed charge, which is for arraignment, and the newly filed charge, which is for arraignment, and the revocation case. On the charges in the The charges in the newly filed case 2016-232 are possession of a controlled substance, methamphetamine, Class D felony, possession of drug paraphernalia, a separate Class D felony, fleeing on foot, a Class C misdemeanor, and obstructing governmental operations, a separate Class C misdemeanor. On those charges, how does Mr. Angel now plead?
Not guilty.
The court will note his plea for the record. On the revocation case, find it. Mr. Bunch, have you had an opportunity to review the revocation file on this?
No, Your Honor.
Well, the reason I'm asking is the petition appears to have been filed on July 1st, and on August 11th, there's a sentencing. Just checking to see if somebody's filed it by mistake, but there's a sentencing order filed in the case, which would indicate the case has been disposed of. I don't know that we're... No.
Was Mr. Russo his attorney? in that?
Mr. Russo was his attorney, yes, correct. And I don't think we have a new case, new revocation case. Mr. Carter, do you have any idea on that?
Judge, I think the sentencing order is the original sentencing order from May 26th of 2016 and filed, I guess, on August 15th of 2016. And in the meantime, the revocation petition was filed. In fact, actually, I have two filed sentencing orders, one from the 11th and one from the 15th.
Yes.
Judge, Mr. Russo's here. Perhaps he can shed some light on the matter.
We've just arraigned Mr. Angel on new charges. He was also before the court on a petition to revoke that dates back to the 1st of July. And in looking at it, since that was filed in relation to this case, the court has entered a judgment on this kind of sentencing order on this.
Judge, I don't have my file. Can I borrow the court file for just a moment?
Maybe I'm misreading the file, and that's what Mr. Carter is suggesting. And so, well, that may just mean I'm not reading it correctly.
No, Judge, what it was is the way it was originally charged and the way the facts of the case eventually came out, there was a major amendment to the case, and that's why there was a plea and charge that way. So on the plea statement, Judge, if you look at the original information had him charged with aggravated robbery, and then we amended, the charge was amended, he pled to a commercial burglary, And
That's back in May?
yes,
Back in
Judge.
May.
And recalling the court's attention on this case, this was one that had originally, the call had come in as a aggravated robbery, but a co-defendant who was the clerk in the store, she had set everything up and it was
Oh,
a
yeah.
pretend robbery.
Yeah, okay, now I remember which case this is.
So
Okay.
my client, Judge, participated in that, and the factual basis for the plea was the fact that he unlawfully entered the store for the purposes of taking money, which made it a commercial burglary.
All right. Thank you. Further clarification. Now I get it. All right. On the case 2016-24, the revocation petition, which was filed the 1st of July of 2016, the violations alleged are that Mr. Angel failed to report to intake as ordered. He failed to provide information as to a residence and failed to report as directed following a home visit. It was discovered he was not living at the residence that he had listed. All of those are allegations contained in the petition. On that petition, how does the defendant now plead?
Not true.
All right. On the revocation, the court is going to set the court handled this case when the plea was taken, and the court's going to set it down for a hearing I'm going to set it down for hearing on September 16th. In regard to the new case, that case is also assigned to the Division 4 docket. Court's going to set this matter in accordance with the scheduling order. I'm setting it for a trial date, May 8th of 2017, a pre-trial date, March 24th of 2017. And I'm going to set it for a reappearance date of December 9th, 2016. Those will be the dates in the scheduling order. That will be entered. Is there anything else to be brought up about Mr. Angel at this point?
Was there going to be a bond sale on the subject?
Let's see. What says the state on bond?
Judge, with regard to case 2016-232-4, he is clearly entitled to a bond based on the nature of those particular charges. The state will request a bond in the amount of $7,500. However, with regard to 2016-24-4, it's a revocation, and because the court has promptly said it, we would ask that he be held no bond on that particular case.
Mr. Angel, I need some information. I guess, Mr. Bunch, I request some information about where Mr. Angel's living, who he lives with, if he's employed, any information like that, in setting bond.
This questionnaire form that we send out shows an address in Harrison. Apparently he's lived in this area for the last 10 to 12 years consistently. Employment's unemployed at this time, he says.
All right.
Family members live in the area.
Judge, one of our concerns is the allegation that Mr. Angel initially did not report to probation for intake, and then if the court looks at the new case that occurred about the 28th of May, part of the allegation is he gave a fake name.
There's also an allegation of fleeing on foot. Which, again, Mr. Angel doesn't seem very disposed to cooperate. I'm going to set the bond to cover both cases at $15,000 cash or professional bond. I'm going to condition that bond upon, if he makes that bond, Mr. Angel is to report forthwith to probation, provide them the address at which he's living at, and it must be a valid address. And I'm going to direct probation and parole to check the address and verify that's where he's living. If he bonds out, he also needs to understand that I've set his revocation hearing on the 16th of September, and he absolutely needs to be there. So those are that'll be the conditions of the bond. $15,000 cash or profession. All right, Mr. Angel, you may be excused.
Thank you, Your Honor.
Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
Fly higher. Go further. Do more. Take it to the next level with Polaris. Whether you're chasing unforgettable memories, manhandling a mountain of work, or pushing the limits of work and play, we've got the perfect machine built just for you. Now's the time to get rebates up to $2,000 during the Polaris Spring Sales Event.
Come see us at 824 North Main in Harrison.
2016-236, State of Arkansas versus Terry McIntyre. Court is going to appoint the Public Defender's Office to represent Mr. McIntyre. Mr. McIntyre is for arraignment on charges of simultaneous possession of drugs and firearms, Class Y felony, possession of firearms by a certain person, a Class D felony, possession of a controlled substance, methamphetamine, a Class D felony, possession of a controlled substance, heroin, a Class D felony, possession of a controlled substance, morphine sulfate, Class D felony, possession of a controlled substance, hydrocodone, Class D felony, drug paraphernalia, Class A misdemeanor, possession of a controlled substance, Prodol, a Class A misdemeanor, all charged as an habitual offender. On those charges, how does Mr. McIntyre plead?
Not guilty.
Plea of not guilty is noted. His case is assigned to the Division 4 docket of this court. The court will set it by scheduling order at this time for trial May 8th of 2017. Let me make sure. I want to make sure on the arrest date. I show the arrest date as July 7th. Is that what the state has?
Yes, Your Honor.
So I'm setting this matter for trial May 8th of 2017 for a pretrial hearing on March 24th of 2017 and a reappearance in this court on December 9th of 2016. That will be the order of the court. Any other matters to be brought up at this time?
Not by the defense.
You may be excused. (2016-234) State of Arkansas versus Christopher Morris. Mr. Morris also has the case 2016-140 on the docket. Apparently there's a revocation case for him as well, 2014-145.
Judge, in case 2016-140, Mr. Morris is already represented by the Public Defender's Office. So I'm going to give Mr. Bunch discovery in 2016-234, as well as the revocation 2014-145.
Court is in the process of approving the appointment of the Public Defender's Office for Mr. Morris in those two cases as well. On the charges in case 2016-234, where Mr. Morris is now charged with possession of a controlled substance, methamphetamine, and possession of drug paraphernalia. Both are methamphetamine, it's a C felony, drug paraphernalia is a D felony. How does Mr. Morris now plead?
Not guilty.
All right. Plea of not guilty is noted. In case 2014-145, the revocation case, which is he's in first appearance, petition to revoke was filed in this case August 16th. The petition to revoke alleges the violation of a law based on his arrest on the charges that arose on August 9th of 2016. That's the basis of the revocation. On the allegations in that case, how does the defendant now plead?
Not true.
Fine. Public Defender's Office is appointed under a plea of not true, and that's noted. I'm going to set that revocation proceeding down for hearing on September 16th. Can both sides be ready?
Judge, I can. But one thing before the court does that. The court also has Mr. Morris appearing on the 16th in case 2016-140 because we had a very long suppression hearing which the court took under advisement, and the court informed us that the court would issue a ruling on the 16th.
Right.
That may or may not have some effect as to how the defense may want to proceed in this matter. But yes, I could be ready on the 16th.
I'll try.
All right. I mean, it's not a very long time to get prepared. It's obvious that the major part of the state's case has to do with a whole new criminal case that's been filed. And I don't want to make it impossible for someone to get prepared, but I'm just saying, if both sides can be ready, let's see if we can't wrap this case up on the 16th, and perhaps all three cases. Okay, it's being set for September 16th. And as the court has noted, 2016-140, I mean, as Mr. Carter has noted, 2016 140 is set for ruling of the court on the disposition by the court on that date. So the court will come to court prepared to rule on that issue, the suppression issue. Both sides got their briefs in, is that correct?
Did we do a brief, John?
Which case, I'm sorry?
Christopher Morris?
Christopher Morris?
I would have to check my file.
Judge, I know whatever I was going to submit, I have submitted.
Okay. Judy, put those all in a separate place. I want to check them after court today.
Judge, if I wrote one, I think you'll be able to make the decision in our favor based on my brief. If you want to rule now, I'll tell you, Judge. I think
Ever the optimist. Of course, you have good reason. Just yesterday, I rendered a decision on a case you briefed over in Baxter County, so you're just suppressing some evidence. But in any case, ever the optimist, Mr. Russo. I admire.
I will check our file, Judge. I'll make sure we've got. If we don't have one, I'll make sure it's turned in. But I remember doing. I thought I remembered it doing it.
All right. All right. Huh? Or just give them to Polly to hold, because I want to look them over in my office. All right. Any other matters dealing with Mr. Morris?
The 2016-234 case, when is he to return on that one?
Pardon?
The 2016-234
Oh, yes. You're correct. Yes. Well, I was considering an earlier setting, but what I'm going to do is I'm going to order him to appear on that case, first of all, on September 16th, but I'm going to set it by scheduling order for trial the May 8th of 17 basis, the pretrial March 24th, and the reappearance, if that case is going forward, of December 9th. But I want him to be there on that case on the 16th of September. So, and then the hearing is set in the revocation, and the other two cases are set on the 16th of September.
I think Mr. Morris had something he wanted to say.
Mr. Morris?
Do I have a bond for it?
Right.
Touching over the other?
I don't. At this point, I'm not going to set a bond. The basis for not setting the bond is I've set a prompt hearing on the 16th of September. These newest charges arising in August come after Mr. Morris already had previous charges, and the court at this time is going to hold off on setting a bond until the 16th of September.
Okay, can I ask you another question?
Yes, sir.
I sent you a letter against the prosecution about a different matter, and I was just wondering if you had received that letter.
When did you send that letter?
4 days ago.
I have not received it in the last 4 days. Of course, I've been out of town Tuesday, Wednesday, and Thursday in court in other counties in this district, and have only briefly been in my office today. It undoubtedly will arrive in the mail either today or, we'll find it either today or first part of next week. I'm not understanding you.
If I may, I'd like to ask Mr. Budd if he could come and see me as soon as possible. I'd like to speak to him on these matters.
Yes, sir.
All right. All right.
Thank you.
You may be excused.
Thank you.
Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
When you support a locally owned pharmacy, you're contributing to the growth of a community. The dollars you spend stay right here to support our local community. Health Mart pharmacies are locally owned pharmacies. There is one right here. Health Mart pharmacists have a crucial commitment to their community because just like you, they support their community. Health Mart pharmacies are locally owned and hometown proud. Harrison has a Health Mart now. Sam Alexander Pharmacy, on the square in downtown Harrison. Health Mart, caring for you and about you.
I'm Randall. I work at the on-site lab at Dental Creations on the square at Harrison. Working with Dr. Wanda is great. She's taught me a lot and showed me a lot, and she gives us the freedom to get one-on-one with the patient. If there's a problem, we can actually come out of the back and do what's best for the patient. Having this on-site lab here with the doctors, that's really nice.
Dental Creations on the square in Harrison, next to the Big Red Boot.
Cases 2010-327, 2013-106, 2015-79, and 2011-300, State of Arkansas versus Monty James Payne. This matter was down before the court. Mr. Payne, my understanding, has a surgical procedure that he has to get to in Fayetteville, and I wanted to try to get this addressed. I have had, the last time we met, there was an issue because Mr. Payne, the DOC wasn't accepting the proposed order that we had entered against Mr. Payne for some technical reasons. I've had discussion since that time with the officialdom of the DOC, and as a result of that conversation, they have withdrawn their objection, and so that paperwork's ready to be processed. Now, what other issues do we have with Mr. Payne at this point?
None. He's filed an appeal bond, and so the appeal can progress, etc., and he just has to keep in touch with his bondsman.
And Judge, Mr. Payne, I can tell the court, has always maintained excellent contact with our office.
Right.
So I do know the appeal's proceeding, and now that ADC's accepted that, depending upon how the appeal goes, we'll be good to go.
All right. So, and there's the bond is good to stay. The stay has been issued with regard to the execution of sentence. based on the appeal bond?
Judge, I believe we took that up before we actually filed the appeals, so it was still within the realm and purview of this court.
Mm-hmm.
So he's out on this court's bond pending the appeal.
Okay.
Okay.
All right. I just don't ever recall seeing the paperwork in terms of whether a stay has been entered on the appeal. So that's based on the appeal. So.
Yeah, Judge, I don't think we got a mandate from the court. I think the court allowed us to do that because judgment hadn't been entered yet.
Mm-hmm.
And because this court still had jurisdiction, I think his bond and his ability to stay out is based upon this court's order and not the appellate court's.
Okay. All right. All right. Mr. Payne,
Yes, sir.
You may be excused. You need to stay in good communication with the Public Defender's Office.
Yes, sir.
I guess they're still you're no longer representing him, and you've passed the authority on the appeal over to.
Correct, Judge. But he can still stay in contact with our office as this process goes through.
Okay. So
I do contact him from time to time anyway.
Yeah.
Well, just stay in good touch
Yes, sir.
with the Public Defender's Office so that when the appeal is decided and all, we'll have good contact with you.
Yes, sir.
All right.
Yes,
all
sir.
right.
Thank you very much, sir.
You may be excused. Boone County case 2015-220, State of Arkansas versus Eddie Allen Taylor.
Your Honor, if I may, this is more my fault than anyone else's. I was not prepared for this, and I am now representing Mr. Taylor. I would ask the court to grant me one continuance on this case, and I shall be prepared upon the next setting, Your Honor.
All right. We had this matter. Let's see. What was it?
And, Your Honor, I'll make it on my motion and waive any issues of speedy trial.
This case was set down for trial on the 19th of September, and the pretrial was set for September 2nd. The court understands that Mr. Nance, as newly hired counsel, wasn't familiar with our procedures, and so under the sequence of events, the court will, at his request, grant a continuance of this matter. Let's see. The next trial period is so I'm continuing the trial to the October 31st trial period as an excluded period. The period of that delay is an excluded period. And then I'll set this matter down for the pretrial down for September 30th. That'll be the rescheduled pretrial will be on September 30th. All motions need to be filed that will be heard at the pretrial enough in advance so both sides can be prepared on September 30th. All right?
Thank you, Your Honor.
All right.
May I be excused?
You may be excused. You also, Mr. Taylor.
Nice to meet you again, Your Honor.
Nice to meet you.
Crystal clear mountain streams, river rapids, and rolling hills with endless valleys. The beauty of the Ozarks we often take for granted. At Magnus Toyota, we never underestimate the value of our customers. As a third-generation family-owned business, Magnus Toyota has been operating here in the Ozarks for over 50 years. When we make a new deal, we make a new friend. Stop in and visit us today and see why our customers say we're the best. Magnus Toyota, your hometown Toyota dealer on Highway 65 North in Harrison.
Well, howdy, folks. Brewster the Rooster here from the Chicken House. I want to tell you about some great specials we got just for you. On Saturdays, you can save 10% off any of our menu items, and on Sundays, we bump it up to 20%. And to keep it interesting, every Monday through Friday, we offer up a special deal of the day that you can only find out when you stop by the Chicken House on Highway 65 North in Harrison. Come on by and enjoy the Cajun-infused flavor in every bite of crispy, crunchy chicken at the Chicken House in Harrison.
You know, we should always remember to have a working smoke detector where we sleep. Let's go, let's go. Okay, we're all safe, we're all safe. In an emergency, you need a meeting place outside the whole family can meet so that you know everyone is safe.
2016-200, State of Arkansas versus Mitchell Christensen. This is a matter that was set previously, but at an August 5th hearing, the defendant did not appear and a warrant was issued. That warrant was served on August 17th. And it was set down for him to reappear on this date before the court. That was by Judge Putman, because he appeared on August 26th in front of Judge Putman and was set over for today's date to reschedule his case for trial. There's not a new scheduling order. The original scheduling order had it for trial in March. The matter was, that's all I can tell you from the file.
I did not hire the public defender's officer. I want to represent myself. I'm a veteran, sir. I'm willing and able to do it and call off the mistrial. I would like a decent bond, please, sir.
Okay. Let me just clarify something on the record. The original scheduling order said his arraignment was to be at August 5th, and a scheduling order was entered setting this case for March 14th of 2017. That was the original trial date set. On August 5th, he did not appear, and the court issued an arrest warrant, a failure to appear warrant. He was arrested on that on August 17th.
I was arrested before that, sir, in Taney County. I was brought over from Taney County, sir.
Sir, I'm very well aware of that. I'm telling you about you were arrested in Taney County, and you were set to be arraigned in Boone County, Arkansas, on the 5th of August, and did not appear on that day. And as a consequence of that, a warrant was issued that was served on you on August 17th. Now, and on August 26th, you appeared in front of Judge Putman, and Judge Putman set the case down to come before the court today. Now, that's where we stand right now. You're stating you don't want to be represented by an attorney?
No, sir. I've not pled no guilty or no contest or not guilty, sir. I still haven't been arraigned on this issue.
Okay. Well, that's what we're going to do today. We're going to arraign you today on the charges.
Thanks, sir.
All right. The court will advise you that you have an absolute constitutional right to be represented by an attorney. In the strongest possible terms, I want to advise you that it's in your best interest to exercise that right to an attorney. You exercise the right to the attorney by hiring the attorney of your choice. And if you go out and hire whatever attorney you want to, then the court doesn't get involved in that, because that's a matter of private contract between you and the attorney you choose to hire. However, if you cannot afford to hire an attorney, you're still entitled to be represented by an attorney. And in that circumstance, if you wish to file for representation through appointed counsel in this jurisdiction, the availability of appointed counsel is through the Public Defender's Office. The public defenders in this jurisdiction are very high quality, and they do an excellent job of representing individuals. Apparently, or at least it was our understanding, I think you did file an application previously in this case with the Public Defender's Office, and the appointment has been made, I believe. Well, maybe it hasn't. But anyway, it looks like you filed an application. At least it's filed in the court file from August 30th. But you, at this point, are you saying you don't want appointed counsel?
That's correct, sir. I want to represent myself.
Judge, the state of Arkansas is going to oppose that. While he has a constitutional right to represent himself, the court has to be convinced that he's capable of doing that. If the court will quickly review the affidavit in this case, and the court needs to be aware that he has had protection orders entered against him in February and again in May of this year, the state believes that there are significant cognitive issues that would make it grossly unjust for Mr. Christensen to represent himself.
I oppose that, sir. I can represent myself in full.
All right. Yeah. Thank you, Mr. Carter. All right, Mr. Christensen. At this point,
I am an officer of the court, sir. I can represent myself. I don't need an attorney. I'm willing and able to do it myself.
Okay. Do you have any background or acquaintance with the law? Have you been through any schooling or formal training in the law?
I know the law very well, sir. Well, I have to defend myself.
Would you please provide an answer to the question I asked? What is your formal training upon which you make that statement?
I have been through the system before, sir.
In other words, you've been charged with criminal behavior before and gone through the system?
I've gone through some petty stuff, sir. Criminal stuff, misdemeanors.
Well, at this point, Mr. Christensen, I'm going to advise you that you're very ill-advised. It's the old saying that a person who represents themselves has a fool for a client. It's a well-known saying in this court's experience, which totals over 40 years of practicing law, most of it in the area of criminal law. I would say that common saying is absolutely true. And if you don't have any formal training in the law, you will be at a severe disadvantage in all future court proceedings. I strongly urge you to reconsider on that decision. Having said that, the court at this time, on your request, is going to allow you to represent yourself. Now, the thing you need to understand is that doesn't gain you any special advantage in the courtroom. If you choose to represent yourself, you'll be treated just as any other lawyer would be in the courtroom, and you will be expected to know and abide by the rules and the law and the rules of evidence, the rules in the courtroom. You'll get no special consideration because you're representing yourself, and you need to understand what that means. Is because you don't know how to proceed, you don't file the right motions, you don't take up the right issues, that can subject you to losing valuable rights and, in fact, perhaps even losing the case. And that is not, the court just wants you to understand that why the court thinks you're making a very, very serious mistake by wanting to represent yourself. Having said that, I'm saying at this point I'm going to allow you to go forward representing yourself. You're before the court today, so I'm relieving the Public Defender's Office at this time from any obligation to represent Mr. Christensen. Mr. Christensen, you're charged with the offense of criminal mischief in the first degree, a Class D felony, and obstructing governmental operations, a Class A misdemeanor. On those charges, how do you now plead?
Sir, I'd like to request a speedy trial and
Sir, you're at a, I'm telling you, this is an arraignment. I'm asking you to enter your plea at this time.
No contest, sir.
You're entering a plea of no contest?
Yes, sir.
Do you know what the plea of no contest means?
I'm going for a speedy trial, sir, yes.
If you enter a plea of no contest, Mr. Christensen, this is just an excellent example of why you don't need to be representing yourself. If you enter a plea of no contest at this point, we can proceed right here today, but in essence, you're setting yourself up to be found guilty in this proceeding right here today if I allow you to enter that plea. I'm not going to do that. You need the advice of counsel, sir. You don't understand what no contest means. On that basis, the court's going to enter a plea of not guilty on Mr. Christensen's behalf. The plea of not guilty is noted on the record. Now, this matter is on this court's docket. It's already set for trial.
What, a year from now?
It's already set for trial March of 2017.
You taking my wife away, man. Oh, better.
Right. We'll take this matter up later. Huh? We'll just stay with the original sentencing or scheduling order. Put that aside. We may call that later. 2016-33, State of Arkansas versus Sean Cook. For the record, the court will find that that Mr. Christensen became unruly and got up and left his position where he was discussing the matter with the court, and the bailiff, the jailer, had to remove him at that point. We'll get back to discussing the case with him at a later time.
In Court on TKO8 Television is brought to you by Campbell Bonding Company. Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
My name is Nikki. I work at Dental Creations on the Square in Harrison, and I'm a dental assist. We're the first faces that the patients see. We get them through the paperwork process, explain what's going on, and just let them know step by step what to expect, and you get to see them throughout the whole process. We want our patients to be happy, we want them to be comfortable, and that's really what it's about, getting the best results while making great relationships